the European Union has been adopted, while in Nigeria, strict sectoral regulations similar to what has been adopted recently in China has been um, adopted to restrict the international transfer of data. And these different transfer models, broadly characterized as data localization, are justified by governments on several fronts, from data privacy to national security, which often reflects the policy priorities of states. But while some of these concerns of African states in relation to the unrestricted flow of data are valid, sometimes they stand at odds with the economic objectives of this country to use the data economy as the pivot for sustainable economic growth. And the Mandela Institute's research project on data localization in Africa aims to explore, how these different economic objectives play out when these restrictive data protection regulations are adopted. Using South Africa, Kenya, Nigeria as case studies, we have so far conducted research on each country, and these country reports are available on the Mandela Institute's website. The aim is to identify policy trade-offs in the area of competition, trade, and foreign direct investment, where data governance needs to be reconciled with the unique features of the data economy. Today, we'll be discussing two of the policy briefs that have been produced under this research project. The first is Professor Clarence's brief on competition policy on and data localization in the three countries we're interested in. And it makes the point that data governance frameworks should adopt a broad expansion of data subject rights to include, for example, the right to data portability, and a cross-harmonization of laws is necessary in dealing with the emerging issues we have in relation to data localization. To understand the economic implications of data regulation, we first also need to know the forms of data that these regulations target. So our research project has primarily focused on the processing of personal data, and this form of data is important for the development of the data economy. And without a full appreciation for the unique characteristics of personal data, this has led to calls in South Africa, for example, to play a more central role in the collection, dissemination, and analysis of data, understanding that key economic advantages are contained within it. Also, in South Africa's draft policy on data and cloud policy, which is the focus of Gabriela Razzano's brief on missteps in the value of data, you will see that South Africa's policy has suggested turning creating digital infrastructures and data centers which hold critical cloud computing into national strategic assets. Such proposals, we think, misunderstand the nature of personal data, and is often due to the characterization of data as a form of resource that can fall under state ownership and that the supply can be regulated. So we see policy positions in South Africa, for example, aiming to derive socioeconomic benefits from its data and to be a common good for all residing in South Africa. And Gabi Razzano makes the point that analogies such as this, including data is the new oil, creates the impression that data can be finite and constrained to the borders of a country. This has also led to calls for regulation to break up the monopoly of tech companies, as is the case with oil companies. These positions, according to Razzano, as she will argue, fail to recognize the key characteristics of data, its generation, its storage, its flow, and how value is generated. Gabi also argues that the non-rivalrous nature of data is what makes the idea of data ownership difficult, and that this means at the technological level, data is infinitely usable, and due to the non-rival nature of data, access to data, according to Gabi, is more important than the concept of ownership itself. And like Professor Claren, Gabi argues that to address issues around data ownership, we also probably need to unroll a bundle of rights such as access, rectification, fair and reasonable usage, among others. So we are going to have an interesting conversation today, and we are going to first start with Professor Claren. Professor Claren is a professor at the Wits Law School. He is also a former head of the law school and a former director of the Mandela Institute. And he wears several hats, and one of his key competencies and expertise is in relation to competition policy. So over to you, Professor Claren. Thank you.
Thank you so much, Fola. Yeah, and thank you to Professor Feroz Kachalia, the current director of the Mandela Institute, and I'm also delighted to be here on a panel with Gabby. Yeah, so without further ado, I think I'll start sharing a presentation and speak to it, at least try to do that. Let me get this going here. Okay. Okay, now can that be seen? Just checking.
Okay. Yes.
Great. Yeah, and I see several people in the participants who have got expertise in these areas. So yeah, I'm sure that we can have a good discussion on these things. And yeah, and the idea of these webinars is really to all be learning about the matter. Okay, so yeah, this is really, as Fola has said, we're discussing effectively two policy briefs here. And mine was written more from the point of view of competition policy. It engaged with data protection, not particularly with data ownership, but I'll come back to that. I want to bring in a different framing, or at least different sets of the term of privacy, as well as data protection or data ownership. And I'm doing that in a considered sense, even though, as Fola was saying, we can talk about these frameworks as data governance frameworks. And part of that reason for using, or at least keeping in play, the theme of privacy is partly linking back to work that I'm really not going to present here, but joint work with Professor Kachalia that talks about where the right to privacy can go in the South African constitutional framework. Yeah, so I thought about this matter kind of, yeah, actually almost trying to do a policy paper, which talk about policy domains actually, and trying to do that at an African scale within this research project, but obviously, yeah, but mostly, well, really only paying attention to developments in Kenya, South Africa, and Nigeria. Okay, so what I did was first to sketch each of the policy domains at the African level. When I say each, I mean on the one hand competition policy, and on the other data protection. Then to look at the intersection between those two domains. They're moving up a level, in a sense, to a global level, and identifying within that intersection at least one important issue, significant issue, that of data portability. I want to play with the terminology a little bit there. And then offering a choice I think Fola was talking about our research project was aiming to look at trade-offs. I'm not sure if this is a precise trade-off, but it's certainly a choice, arguing between a strong form and a weak form of data mobility. And then cascading that at least a little bit down into the African jurisdictions, which then begins to move on on data localization more broadly, providing a perspective there. Okay, so the basic view is that there is a difference between these two different policy domains, that the African competition policy domain is consolidated, or certainly is more consolidated than the data protection domain. So whereas one domain, that's the conclusion of this slide effectively, that whereas one is consolidated, the other is consolidating. So there's lots of work, there's lots of experience to back up that point, but just a few stats are here. By 2015, the World Bank had reported 27 countries with competition laws. A few years later, there were 33. This is out of, I guess, 50 odd jurisdictions, right? On the other hand, looking at the data protection laws, there's definitely a bit of a lag there, where there would be 12 countries adopting new laws, with 32 having done data protection laws as of 2020. So the point from Greenleaf and Cotier about the adoption of data protection laws is that Africa is the place that is most quickly adopting the region in the world, adopting those laws rather than having those laws in place at the moment. So a little bit flippantly, but I'm saying there the winner is the competition domain. And I think that's also, the numbers are maybe a little hard to compare, but when you put into place the authorities, and certainly if we started going to the level of budgets and staff as well. So there were 12 regulators as of 2018, with a few more in the pipeline, as compared with 32 national. Well, actually that precise figure does include some regional competition domains as well, as of 2015, right? 27 and 5 regional. You can also see this not only at the level of established authorities, but also thinking about the enforcement connections, so the networks. And not to say that there aren't any data protection networks, there are, but the academic literature was identifying one functioning one in 2018, whereas on the competition side, you've got, not necessarily in every region, but you've got functioning competition enforcement networks, plus you've got an overarching body, the African Competition Forum, I think it is, that is been functioning for a while now. Okay, so that's the first step. Second is then to say, well, what's the interesting issue here, and where does it fall in terms of these two policy domains? Obviously, the assumption of talking about two domains is that they are separate, or at least that they can be conceived of as separate entities. So if you play around with that idea, one thing is you can say, well, is there actually a whole nother policy domain here? Is data localization, data portability, I'm going to see the two in counterpoint, I'm going to suggest that later, is that itself a kind of policy domain? I didn't go there. But I do think it is worth pointing out the degree to which there is attention and drive and resources around this issue, such that it might begin to satisfy the requirements of a policy domain, in the sense of having policies, in the sense of having enforcers, in the sense of having enforcees. Maybe that might be more in the private sector than in the public sector, but you certainly could make some kind of argument there. But the brief didn't do that. It stuck with the idea of these two domains who nonetheless intersect, and then spoke about slightly shifting from regulatory language to rights language to a right of data portability. And surveying, looking, and drawing quite a bit from the Australian recent, maybe not so recent now, but the Australian developments, argued for understanding a right of data portability, which would be, effectively an individual right, a right held by either a legal person as either an individual or as a firm. And actually that first move is important for the strong form of this right. That's because if one thinks about it, maybe as the Gajima judgment would want to have it, as a right that would only inhere in red-blooded individuals, then if you didn't have it for for firms, it would diminish the competition effects of that right, certainly when that right was translated into regulation. So the beneficial dynamic effects of competition would be lost. Secondly, the second attribute of distinguishing a strong form from a weak form is about what data is actually piled in there. So I'm suggesting that there is data that goes beyond strictly linked personal information. That would mean that there would be a fairly wider range. It would be the kind of data that could be associated with an individual. And then third, and I'll have one slide at the end that maybe talks about this more too, but what is almost the remedy? What is the power that the individual or the firm would have over the data to take it from one place to another? Would that, what degree of access and control would that be? Would it be a once-off move? Would it be a move at request? Would it be a request to set up an ongoing transfer of data? Those are the questions that I think are involved in choosing between the strong form or the weak form. Okay, so then having set that up as the kind of issue, what's happening? So this is about intersections on African ground. The paper explores a little bit the two jurisdictions that I know better of these three. It argues for a difference between Kenya and South Africa, and where the telecommunications regulator, we're not talking there about the data protection regulator in Kenya, but I think we could call that, at least from the point of view of the competition regulator, as the sector regulator, that is the non-competition regulator. That in Kenya, the developments here are driven more by the sector regulator than by the competition regulator. Whereas in South Africa, the competition authorities, I'm not actually saying that they're necessarily driving the developments. As I ended up writing this and trying to characterize it, it was more that their voice was at least equally being heard. So in at least in contestation with the telecommunications regulator. So that's the difference between those two jurisdictions. And in terms of where the content of the right of data portability would play out, then I think you can read from that difference towards the likely outcome. So where does data localization fit? I'm seeing data localization as a counterpoint to data portability, at least where data portability is being seen in the form of a individual or firm linked right. So it's really a sovereignty, effectively a top-down sovereignty versus rights. Again, arguably in this intersection, but firmly sourced in data protection. So some part of the brief looks at Kenya's data protection law and some of the policies, not of the telecommunications regulator, but of the Information Technology Development Association as sourcing data localization requirements. So I think on the whole, one would say that data localization is actually more prominent in Africa than data portability. And I have looked at a few of the documents at the continental level as well. And while one could say that there's an exception for South Africa, it's really only a partial exception. Because you couldn't say that data portability was more prominent. Okay, then that's getting pretty close to the end of my presentation. I'm just going to quickly look at two more slides. This is one that pulls on some recent work by Andreoni and Simon Roberts, looking again from a competition point of view, specifically into digital economy. And I found it interesting. I was looking at their work, where is privacy and data governance? And it really pushed me to, or it allowed me to think about the right of data portability in even stronger ways, perhaps, than the ones that I discussed in the policy brief. And again, it plays a little bit with terminology, but on that third dimension, if one, and this is really moving into the kind of frameworks of open data, if one looks at a right of consumers to request that data be moved or shared directly between, for instance, a business that a consumer is interacting with, and then a third party on an ongoing basis, that's a even stronger form of the right of what I'm calling the right to data portability, which maybe should have a different term, which maybe should be called a right of data mobility, than at least the weak form of the right of data portability. So I think that, I argue, would be the import for the African framing of that right. And I don't really explicate it here much, but I think that would fit with, well, both the focus of this webinar and discussion, which is really on issues of ownership and the economic consequences of the governance and the framing of data. Yeah, the governance of data, I guess we should say, and also fit with what, at least in Africa, is a quite often strong relationship between competition authorities and consumer protection authorities. So I haven't said much there about the regulatory authority on the consumer side, but that fits within the competition framing, or can do so. Yeah, so I think I will stop there. This slide gives the site to the joint paper, that I mentioned in the beginning that Froze and I did. There's the Simon Roberts and the Andreoni piece, and a couple of other, I think, good sources that are drawn upon a little bit in the paper. So thank you very much, Bola.
Thank you very much, Prof. Really appreciate that. If our guests wouldn't mind, we would take questions for Professor Claren after Gabi Razzano's presentation. Gabi Razzano is currently the Executive Director of OpenUp. Previously, she used to be the Executive Director of the Open Democracy Advice Center, and both organizations partner with governments, organizations, industry leaders, and civil society to identify and make accessible information that supports open communities and an empowered citizenry. And Gabi will be focusing primarily on the issue of data ownership in our presentation. So over to you, Gabi. Thank you.
Thanks, Fola. Let me just open the presentation. All right, is that visible as a PowerPoint?
Yes.
Okay. Okay, I'll be talking a bit more about a discrete South African case study, which deals with issues of both data localization and ownership. And part of the reason I've drawn out those two issues isn't to create a kind of straw man within the policy I'm looking at, but rather because I think those two issues bring out some interesting insights into the policies and politics that sit behind a lot of attempts at data governance. And I think through the South African case study, we can learn a little bit. There's some interesting lessons to learn about, data governance more broadly for the region. But, one of the primary issues, one of the sort of more foundational issues that the paper introduces is just the idea that, of course, data governance is not just about data protection. Data protection obviously being, the focus of significant amounts of data governance in relation to personal data, but rather that data governance is also about access and interoperability and security and trust, and also about control. And this issue of control is very, I think, for trying to understand what the remit of data governance and data policy should or shouldn't be. I think the idea of control has a lot more to tell us about extracting value from data necessarily than the idea of data ownership, which is basically just the sort of central kind of point I'm trying to set up. But the South African case study is based largely on the proposals made under the Telecommunications Department's recent cloud policy. And so it does, within the cloud policy, it posits a form of partial data localization, really. That's not the technical term, but, a form of data localization where, for instance, certain kinds of personal data would be required to be held both domestically and over borders. And then also posits ideas around state data ownership. These are in different sections, but I think have some connections that are interesting to bring out. But importantly to note in the cloud policy, obviously, is that that's not all the cloud policy is about. Cloud policy obviously deals very fundamentally, or tries to deal, or at least proposes to deal very fundamentally with issues around data infrastructure and the provision of data infrastructure as a foundational issue for data governance. And I think that's a very, very important point. But then, unfortunately, the policy itself doesn't necessarily focus enough on the mechanics of. I think a lot of data. What is interesting about a lot of the work on data governance that I'm seeing in the region and is very noteworthy and positive, is the idea of trying to deal with gaps in data infrastructure first, and digital infrastructure. Many of the same conversations on lacunas in digital infrastructure that have been happening more in the realm of telecommunications policy, but continue to be, an inhibitor for digital progress in the region. So those are all good nods. But these ideas on ownership and localization, I think, might reveal some interesting areas for consideration. So the ownership provision is quite specific. It says that data generated in South Africa shall be the property of South Africa, regardless of where the technology company is domiciled. And that government shall act as a trustee for all government data generated within the borders of South Africa. So that provision on trustee starts to borrow from a lot of the work that's being developed around data trusts as a kind of positive mechanism for exerting control in a data governance conversation. And throughout the policy, but itself, I mean, a lot of those provisions on both localization and ownership stem from, some very fundamental policy positions that are quite consistent in the South African context. The one is towards a kind of centrism in policy, particularly in technological policy development, and I outlined some of the different examples of that. I think obviously this is in a direct response to a lot of the concerns raised, particularly in a data protection context, about the nature of, the global data economy and data extractivism. And while that often is about the extraction of personal data for economic benefits of companies that aren't locally domiciled, I think it also links to other forms of data as well. But I think, Jonathan's paper also discusses this a bit. There is this conflict between attempts to sort of through policy promote centralized state capacity for technology and technology development, which is contradicted by the real mechanics of how technology in the public sector is rolled out in the country generally, which tends to be through different forms of public-private partnerships, many of which my organization engages in, for instance. But I think the policy paper also comes within a South African context where there is a growing body of policy and law that is directed at data governance, such as the Protection of Personal Information Act. But there is certainly a position taken by the policy which sees that the foundations for good data governance are centralized consolidations of state power in relation to data. And while you can appreciate that position, there are some issues with that which stem from the realities of what the nature and value of data are within not just an economy, but within a society. And I think that's an important thing I would like to highlight, throughout my different work, is that, the conversations on data and data governance are obviously very economically, uses a lot of economic language, particularly as a lot of the drives in data and digital governance are coming through, for instance, the African Free Trade Area Agreement and those kinds of, economic pushes or whatever. But I think sometimes the social public values are lost in those conversations, although they're not obviously irreconcilable at all. Of course, they can very neatly be dealt with together. But to talk a little bit, just in brief, about the nature of data, this is that table, the traditional table from Elinor Ostrom's work on common and public goods. And you can see, data in its nature is is non-rivalrous and also partially non-excludable, in the sense that there are different forms of excludability that are artificially rendered through law. So, proprietal kinds of provisions, intellectual property laws, and those kinds of things, but only certain kinds of data. But that sort of data sits somewhere between public goods and low congestion goods, which is weird. Oh no, actually, anyway, let's ignore that diagram because I think that's wrong. But to talk in brief a little about some of the economic values of data, it's largely the collective nature of data from which both firms and public sectors are able to derive benefits. And it's the ability to store that data, which is where digital and data infrastructure becomes so important, which is why a cloud policy is such an important step in trying to render value from data. But it's that collection and analytics, the capacity, the capabilities to analyze that data which is largely not static. So a lot of policies, and interestingly, even policies that seek to engage with cloud data on the cloud seems to discuss data in a kind of nature which believes that it's static, that it's still stored on databases that can be put on a USB and move from one place to another. But of course, in a modern digital economy and data economy, it's the real-time access to data for development and analysis that really starts to be the position from which we derive value. But it's also important to remember that data is, of course, largely a factor of production. So in other words, it's not the data itself that's necessarily value, but it's the ability of that data to improve products, and whatever that product is, the development of products, that is quite important. So I suppose what I sort of try and err towards is that deriving value from data is more about its control than about its ownership. With personal data, it become, there are nuances also then to personal data. And again, I reflect on data extractivism and those kinds of things. But essentially that, with personal data, what's so interesting about personal data is that, of course, while the risks are borne by the people who are the data subjects, the economic values of that data are extracted by other people. But of course, in order to gain economic value from data, it's the firms and the businesses that are instituting, that are expending costs in order to control and analyze and those kinds of things. But those conversations on the economic value of data are of course very important, but there are also inherently social values to data, social values both as the values that data can have to society, but also the public values, in other words, the public sector kinds of values to data that are very important too. And, there's obviously the role of data and information in public participation and these kinds of things. And, a lot of the conversations on data governance are starting to talk about data, and particularly within the sort of sustainable development context, as of data and digital, which are not the same thing, but, are often shoved together for leapfrogging development imperatives in the region. And so, a policy should be dealing not just with considerations of economic value, but social value as well. And, within the context of those social values, again, it has a lot more to do with the movement of data and the availability of data and the ability to access data, or not just more, but just as much as it does to deal with the containment and restrictions to accessing data. So in other words, policy needs to deal with both, which seems a twee point, but, I think it's essentially the point that Jonathan's paper is trying to make as well, obviously with a bit more academic rigor. So looking at, localization and ownership together, there are, when the policy documents and on my policy paper, when the talks about localization, there is a sort of contradiction in a policy that is essentially designed to recognize data infrastructure shortcomings in a country, and then at the same time obliges almost immediately the use of such infrastructure. And that's a fundamental contradiction that I just wanted to bring up, because I think it's an important point to think about. A lot of the costs in requiring local storage or local cloud storage, and are then borne, the economic costs are borne by local companies, and the risks borne of inadequate data protection are borne by locals as well, which is just a flag. But within, and then I just touch briefly on ownership again, that, ownership seems to be very much a reflection of sort of protectionist attitudes within the data policy that do not necessarily fully consider the benefits which we actually want to derive from data, both the social and economic development. Blah, blah. Anyway, so then in the paper, I then turn to considering the law and data ownership, and then a bit further on law and policy and their roles. And I go a bit more into it because it's quite a fun thing to actually discuss, and I really enjoyed that section. But it's a bit more, there's a little bit more about it in the paper, but essentially that, that there is to talk about data ownership is it's a lot more complicated than necessarily, even within a particular context like the South African context. It's a difficult question. The law doesn't easily find itself able to deal with notions of incorporeal ownership anyway, and certainly the idea that data ownership is easily established is something that isn't reflected on the nature of data itself. But essentially that, the main point being that there are all these different and fun considerations within the interconnections between law and data ownership, which are also slightly different when it comes to personal data ownership, which the Protection of Personal Information Act seems to have a very clear position on, but I don't think is actually as easily resolved as the Act itself says. But the point is simply that, to establish data ownership of data would certainly be a legal question and not one easily resolved by a policy. So there are two kind of main gaps in terms of the cloud policy, which could be met through a little bit more nuance. The one should be creating realizable mechanisms for personal data protection, which I think is what, a lot of that work on data trusts and that can do, but also to highlight interoperability and data portability as a means for ensuring access to data within a sound data governance regime. And really the position of the paper is that, a data governance regime is not just about personal data, it's about data. And it's not just about data protection, it's also about data flows and data control. So the idea, data control, the ability to control data doesn't need to be sourced in ownership, and it doesn't need to be sourced in full localization. So some of the lessons that can be taken from the policy brief, I think, and applied to other areas, for instance, in Kenya and Nigeria. So Nigeria has the localization of financial data, for instance. But some of the broader lessons are, one of the points in the paper is just to address how taxation is a mechanism for trying to, derive economic redistribution from data economies. The other is that localization requires data specificity given data's value, while still engaging data risks, and that the realities of data's nature and data's value must inform both legal approaches and policy approaches to data governance. And that legal clarity on data governance also requires specificity and acknowledgements of the challenges in legal and regulatory constraints. The law assists with normative guidance. So that, in brief, is the paper. Thanks for the opportunity to speak. Thanks, everyone. I should have done a nice thank you at the beginning, and I didn't. So
Thank you so much, Gabby. Really appreciate that. So I will now open up for questions. One has already come in from Isakmina asking if any of the issues that have been discussed today should be considered for inclusion in the efforts to make PIA fit for purpose in the digital age. I think this is a question that is, and you know, issues around, for example, open versus protected data, online data access, ownership, and data management. Do you want to go first, Gabby?
Yeah, I can, definitely. Isaac putting the screws on us to make submissions to the PIA Amendment Bill. Isaac, I've been on holiday. I will look at it. No, definitely. I mean, I think in a South African context, that there's definitely work to be done about PIA, you know, not just through expanding requirements for proactive disclosure, but starting to reframe access to information to understand it in terms of data as well. I mean, I think one of the things that was positive about having an information regulator who deals with both privacy and access to information was the potential to create a political champion for open data, which doesn't exist currently in our context. I think for instance, that data policy I'm talking about is very interesting because it's one of the few, well, not one of the, okay, it's a policy document that really, really tries to engage with open data and mechanisms for open data in a way that South Africa hasn't been necessarily very good at doing up till this point from a policy perspective. And so but I don't know if that opportunity is to be realized. And, you know, sometimes one wonders what is a statutory issue and what is a policy issue, and you know, where you might get the biggest tractions between the two. But I think the Office of the Information Regulator as a possible champion for open data would be a really positive thing. But whether or not that would require amendments to PIA, I don't know. It probably wouldn't. But certainly PIA itself could be amended to have more manifest or express mechanisms that recognize data and expand on the proactive data disclosure provisions.
Thank you, Gabby. And for Professor Claren, we have a question from Michael asking, on the competition front and given the global nature of many of the players in this space, what kind of international regulatory cooperation is necessary to really have an impact on competition in the digital economy, both in South Africa and other African countries?
Sure. Can I also give a quick answer to the previous question?
Yes.
Okay. I mean, I agree with what Gabby said. And I'm sorry I didn't show that last slide, Gabby, that said everything in your paper was correct. But but Isaac was asking about PIA and making it fit for purpose in the digital age. I didn't get the precise framing of the question, but I think almost regardless of the framing, my answer is going to be yes. And there's another piece of work that I'm working on at the moment, which is looking at the implementation of PIA post-apartheid in 3 different technological steps. One being the technologies of paper and documents, the second being the technologies of databases, and then the third, the open ecosystem. Gabby, you've probably got better terminology for this than I do, but where, as you were saying, data is truly dynamic. You can't locate it in one, you can't even say that Home Affairs, say, has my data per se. The reason that that's, I think, really important for answering this, I think it was an important question, is that it really shows how, and maybe this goes back to particular concerns of mine, but I truly think that the rights of access to information and the right to privacy are intertwined and entangled. And therefore, we need to look at different ways in which that happens. What that means is, and this was an unstated assumption, I think, for both Gabby and myself, is that privacy really matters here. And in fact, access to information can give us some rights content, as well as now an effective regulator with information regulator about that. So I would certainly support and would think that, on the competition domain as well, real support for making PAIA, fit for purpose in the digital age and recognizing its interaction with privacy and data protection. Not that that isn't already to some extent recognized. I think it goes beyond more, it definitely goes beyond the proactive parts. Okay. On the second question, the kind of international cooperation, and actually Gabby may have a different view here, but I have a generally positive view of the sort of soft forms of cooperation that are at the moment in the competition space in Africa with the African Competition Forum, and in Southern Africa between the different competition authorities. I think that allows for the potential, I wouldn't say that we've seen it yet, but the potential for actions and activities such as the ongoing market inquiry, the online intermediated market inquiry that the Competition Commission is engaging in right now, the potential for that to be a point of connection to other regulators. And I feel like if we went too quickly towards centralization and a mirage of control under sovereignty or ownership, metaphors, languages, we would miss those possibilities. But I think the question is a very good one. And I could imagine where, it really might be different in different, particularly in different national contexts. I hope that helps.
Thank you. Gab, did you want to add anything? And while you're also hoping to answer that, I am curious in this idea of data trust that you spoke about, and how we are going to operationalize that in practice.
Yeah. So on the competition question, I mean, it's not really my area, but I do think sometimes, I suppose the sort of cynicism in my policy paper about, political technocentrism is also because sometimes it undermines some of the developments that are happening in the regulatory space that are really interesting. So, for instance, I think in this policy document, the cloud policy document, my beagle's participating. She's also upset. There are, only passing references to the competition regulator. There are only passing references to the information regulator, and there is an attempt, to create a politically centered discourse. And part of the problem of that is that lacks, the sort of multi-stakeholderism that a lot of the regulators are able to facilitate because of the nature of their role. So they have a lot of, discussions with a variety of players. I mean, I'm not saying they're perfect, obviously not, but there are. So, for instance, I think the Competition Commission's market inquiry, the Competition Commission's paper on digital economy, the Competition Commission's involvement that I'm on the fence about, but like on the WhatsApp issue with GovChat and the interdictor provided, those are very interesting developments that that are at least starting very important conversations. That then I think sometimes the centered national policies can't skim over, and are very interesting. I like that. WhatsApp interdict judgment is like one of my favorite things to read. Full nerd position. So that's just a brief touch on there. To touch on data trusts, I mean, data trusts are still a very, it is a very, I like to talk about data trusts because I think there are a lot of shortcomings in the traditional role of sort of consent control and consent notice and consent procedures for the exerting data protection that currently exist. So in other words, most models of data protection are fundamentally see individualized mechanisms for protecting one's own data as the key mechanism for serving protections. And I think there's some gaps that creates that's insufficient, and that there might be other models for or mechanisms for providing protection while also bearing in mind the imperatives of data sharing or whatever, that maybe stuff like data trusts can facilitate, or if not data trusts, then data stewardships, because of course data trusts are based on property ownership, and there's some complications in a South African context about how that would be realized. But really that there are maybe more conceptually mechanisms which could form parts of like communal or group protection that would be well placed for, better placed for dealing with the possibility to share that data in context, like for instance, medical data, particularly epidemiological data, what kind of group mechanisms for protection and sharing might serve those. So, but data trusts are like, still quite conceptual, but or not conceptual. There are particular examples being looked at in different countries, but I think it was really interesting to see the incorporation of trusts within the policy document. It's a bit of a waffle. Okay, apologies.
Thank you, Gabby. And I will take the final question for Professor Claren from Majani Pile, asking if researchers instead looking at portability and interoperability issues in the context of trading services and value this could bring to implementing the AFTA protocol on trading services. Maybe this could help contract the rivalry between regulators and competition authorities over data governance. And I should do a brief plug in here that we'll be having the last of our conversations on the Mandela Institute's project on data localization next week, where we'll be focusing specifically on trade and foreign direct investment. Hi, Prof.
Yeah, okay, so I think that question and the earlier one from Markovits about the kind of international regulatory cooperation that's necessary are both really good ones that are getting to the issues. I think it's, I think I spoke a little bit earlier more about the sort of institutional part of it, but if we talk about the style of regulatory cooperation, I think it needs to be, well, it's very light touch at the moment. It's very much information sharing. There can be learning, ideally, in different contexts. I think it's also important to say, and this is actually another point of shared assumption, I think, between Gabby and myself, is that, we both see quite a lot of economic value here, right? There are huge benefits in digitalization, huge changes, positive that are going on. So it's important not to move too quickly in a command and control way so as to cut off. You know, there's even the economists are talking about the actual definition of industrial changing to blur the edges. There can be positive spin-offs to even, sorry, Gabby, the industrialization. Okay, that last question then is, services where, yes, I think that paying attention to, in my view, strong or strict forms of data mobility or data portability can potentially unlock, even GASP, different ways in which legal services could be rendered. That would be actually, you know, looking at the objective of access to justice rather than, you know, compensation for lawyers, frankly. And I think also, yeah, that could, I mean, maybe it would be a bit optimistic to think that that could look at the rivalry, because concurrent jurisdiction is a inherent fact here, although rivalry is not. So taking even an industrial policy perspective, you know, we're trying to reduce rivalry or to constrain rivalry and challenge it, channel it and condition it in effectively positive ways, but not in butting heads, certainly between public regulators, counterproductive ways. So thanks for the questions and the discussion.
Thank you very much, Professor Claren and Gabriela Razzano, for these excellent presentations. And thank you to our guests as well for attending this conversation and enriching this conversation. Like I stated earlier, we'll be having our last conversation on data localization next week with a focus on trade and foreign direct investments, and all published papers and country reports and policy briefs are available on the Mandela Institute website. Thank you all.
Thanks, Paula. Bye.